Good morning. Welcome to another session of oral argument with the 5th District Court of Appeal in Zoom hearing world. I am Judge Lambert from Marion County. I am the presiding judge this morning. The panel members for oral argument in this case, you have Judge Jay Cohen from Orange County. And we are pleased to have sitting as an associate judge this week, Judge Robert Siegel from Brevard County, the 18th Circuit. He's a circuit judge down there. He sat with us, sitting with us today. He sat with us Tuesday. Done a real good job. We appreciate his willing to help us here. Okay, this is case number 19-3130. Istvan Hovorka, I apologize if I'm mispronouncing anybody's name, versus Christoph Levine, etc. You see the clock up in the left-hand corner. Each side will have 20 minutes for argument. We will set aside 5 minutes for rebuttal for the appellant. Unless the appellant wants some different amount of time, let me know, and the clock manager will adjust that accordingly. Again, we are being watched on YouTube or being recorded on YouTube. Whether we're watched or not, I guess is a different question. So keep that in mind with any of your comments, that people will be able to hear what you're talking about. So that being said, Mr. Walters, you are counsel for the appellant. Whenever you're ready, sir, you can sit down. Unless you're more comfortable standing, feel free to sit down with your argument.
Thank you, Your Honor. I actually I'll take the opportunity to stand if that's okay.
That's fine. Go ahead, sir.
Your Honor, if it may please the court, I'm with the law firm of Dean Ringers, Morgan and Lawton, and I represent the appellant Istvan Hovorka. Your Honor, we are requesting that the court find judicial jurisdiction over all the appellees, Your Honor. We also are requesting that the court reverse the dismissal in relationship to the forum nonconvenience. And at the very least, Your Honor, we will request that the court remand this matter back for a limited evidentiary hearing on the issue of jurisdiction. Your Honor, this is a case where my client is a French citizen who is a physician.
Mr. Walter, we're familiar with the facts, and indeed, I don't know about Judge Siegel and Judge Lambert, but I mean, I had to actually graph out, all the various entities involved, and it strikes me, you start with some folks from France that enter into this agreement with this very specific venue provision in France, and I recognize that you go through these series of entities, but Florida seemed to have very little contact with this matter.
And Your Honor, that's where I believe the error has been made. Florida, in fact, actually does have significant contact with this matter. Your Honor, LDR Medical manufactures the device, if you will, that is at issue. Your Honor, LDR, through a exclusive distribution agreement with LDR Spine, literally sells that device to hospitals and doctors in the state of Florida. In 2016 alone, Your Honor. Did
the original assignment prohibit that?
It did not prohibit that, Your Honor. Matter of fact, the original assignment was to permit the sale and distribution and marketing of this product worldwide. And Mr. Levine was the president of LDR Medical at the time when my client entered into this agreement. Since subsequent to entering to this agreement to assign the rights, Mr. Levine took it upon himself to figure out a pretty significant way of being able to dilute my client's royalties. In doing so, he entered into—
But of course, your client could bring an action in France. Mr. Levine, I believe, is a citizen, and I think of both. I guess he holds dual citizenship both in France and in the United States, correct?
Your Honor, he does. But my client would not be able to bring action in France because it's more than just Mr. Levine that's the defendant here. Your Honor, there's LDR Spine, which is a United States company with no indication that they do any business in France. You have.
I understand that. I understand that in France, probably, Levine is your defendant, but he is I mean, I don't know whether a judgment against him is a viable judgment or not, but he seems to be, the main focus of the litigation.
Well, Your Honor, he is definitely the orchestrator of this conspiracy, but there are considerable other co-conspirators, including LDR Spine, including LDR Holdings, including Zimmer Biomet Holdings, including Zimmer Inc. All of
Now,
these.
did they concede or stipulate that they would be subject to the jurisdiction in Indiana?
Yes, Your Honor, there's been a stipulation for the judge to have jurisdiction in Indiana. However, the same.
How about France?
They have as well as my understanding that they have, but here's a problem, Your Honor. Not all the parties can be available for jurisdiction in France.
Why not? I thought one is a citizen and the others agree to jurisdiction there. Can't you consent to personal jurisdiction?
Well, Your Honor, in regards to another forum, you have to also determine whether that forum is adequate to deal with all the claims that are brought. We have an unjust enrichment claim. We have claims of interference of business relationship. Your Honor, there has been no testimony nor evidence to support that France or any other jurisdiction is quite adequate to handle those claims that were brought here. And also,
well, it's either France or Indiana. So you're saying you think Indiana recognizes those causes of action in their courts?
Well, Your Honor, in relationship to Indiana, it's unclear if all the parties, if you will submit. We have Zimmer France, Your Honor, who has not stipulated to jurisdiction in Indiana, and based on their contacts, I'm not sure that they would even have jurisdiction in Indiana, because that was not stipulated in relationship to Zimmer France. And so, Your Honor, it's also a good reminder that the plaintiff should at least have the opportunity to select their forum. It is clear, Your Honor, that there are significant contacts here in Florida. The theft, if you will, of my client's royalties occurred in Florida. Mr. Levine Mr. Levine was
the theft of royalties probably occurred everywhere. I mean, if they market this in all 50 states, then it occurred in all 50 states.
Your Honor, that would be true. What the evidence supports now is that it in fact happened in Florida. While I would presume we will later discover that they have sold in every single state, but we're very much aware of what harm they have caused in the state of Florida. And that harm, Your Honor, is the dilution of my client's royalty when Christophe Levine, as the president of LDR Medical and also the president of LDR Spine, entered into an exclusive distribution agreement that permitted LDR Spine to only pay 35% of each sale to LDR Medical, causing my client's royalty, if you will, to be at most paid out up to of only 35% of the sale. That was a conscious, knowing attempt to reduce my client's negotiated royalties. And again, LDR Spine was very much aware of what it was doing. LDR Holding was very much aware of what they were doing. All of these co-conspirators, Your Honor, have benefited from the revenue that's been stolen from my client. And Your Honor, it goes as far as when Zimmer Biomet Holdings bought LDR Holdings for $1.5 billion, they were supposed to pay my client 1% of that sale. They failed to do so, Your Honor. This has been a scheme that has been created just to, it's almost a shell, it's truly a shell game, Your Honor, because from the time.
Well, Mr. Ward, I understand your theory of liability. One of the things that strikes me, they file affidavits in support of their motion to dismiss, and I agree with your contention that you don't have to necessarily file counter affidavits if you think that you can rely upon the same depositions and other documents to defeat the motion to dismiss. I don't see any reason that isn't permissible. But it strikes me when I went through it, and I've spent a lot of time going through this record, that you've taken many of the things out of context in support of your opposition to the motion to dismiss.
Your Honor, it would, and I'm not sure specifically what specific fact that or assertion you're representing that we have taken out of context, but that's clearly what the appellees have represented. They represent that the letter that Zimmer Biomet Holdings sent to the Florida Supreme Court was not, in fact, them specifically, even though the letter, Your Honor, only states, the letter states specifically, the undersigned have facilities and do business in the state of Florida. The undersigned is Zimmer Biomet, Your Honor. And the appellees represent that we've taken that out of context. Your Honor, when it comes to the real property that is owned by Zimmer Biomet Holdings based on their 2015 annual report, corporate report, it states Zimmer Biomet Holdings, Inc. When it, on item 2 where it states properties, it says Jacksonville, Florida, business unit headquarters and manufacturing, owned 85,000 square feet. It doesn't say their subsidiary as an appellee seek to represent and state that we take it out of context. It actually is completely in contrast to the assertions that their corporate secretary, Heather Kidwell, makes in her affidavit. Her affidavit states that Zimmer Biomet Holdings does not have any property, Your Honor, in Florida. But in fact, they do, based on their own corporate filings, Your Honor. And during her deposition, she seeks to, if you will, rectify her representation by representing someone else. Your Honor, there's no information to support that conflict. And at minimum, the court should have a limited evidentiary hearing to assess the veracity in live testimony of this person. What the lower court has done is basically taken all the information represented by the appellees as true, instead of doing it on the behalf of the plaintiff, if you will, at the pleading stage. Your Honor, not only does LDR Medical represent, it does no business in Florida. In fact, it manufactures the device that is sold in Florida through an exclusive distribution agreement. Clearly, it should be aware that if anything happens with that product in the state of Florida, once it's implanted into a patient, that they would be held in the courts of Florida. How can they represent that they have no connection to Florida, Your Honor, when in fact, you have literally submitted your product in the stream of commerce in Florida? You've hired LDR Medical as your exclusive agent to market your product here in Florida. It sold $4.6 million just in 2016. And again, we're not talking about the other years that it was sold here. And again, we're talking about Moby C, Your Honor. We're not just talking about other items they may have sold. Zimmer Biomet represents it does no business here, but yet still Tony Resenda's affidavit states that as LDR Spine, as their agent, also sold Zimmer Biomet Holdings other products in the state of Florida. Zimmer Inc. represents that it has no dealings with this, but yet still they're registered to do business. So that allows for us registered to do business in Florida. That allows for specific jurisdiction, Your Honor, because they all have received revenue from the theft, if you will, of the sale of my client's royalties. Your Honor, so
are you suggesting as a matter of law that if you're registered to do business in Florida, you're subject to Florida's long-arm jurisdiction?
Yes, Your Honor, that's what the court has already found. Your Honor, they're subject to jurisdiction if you consider the Venetian salami matter, where there's two prongs, where we correctly pled that the long-arm jurisdiction allows for the court to have jurisdiction, but the second prong addresses the minimum context. The courts have found that you're registered to do business is a factor, but it's not just the fact that they're registered to do business, Your Honor. They've been involved in 96 lawsuits in the state of Florida. How can they represent that they don't expect to be held when they've already defended themselves 96 times? They've also, Your Honor, admitted that the Florida courts have jurisdiction in the case Howard versus Zimmer Inc. in Orange County, Florida. So again, it baffles me that they can represent that there's no expectation in this, and Florida wouldn't have jurisdiction over that. Your Honor, the court also erred in its conclusion that while it found there is jurisdiction of LDR spine, but there is no, if you will, forum nonconvenience. And as I spoke in relationship to Judge Lambert's question, you have to not only have an available forum, but you have to have an adequate forum for all parties. The court, and specifically this court, has already addressed this issue in Swana Bank Limited versus Cato, 734 Southern 2nd, 537, which is a 5th DCA case, ruled in 1999, where it states specifically that an alternative forum is available when the entire case and all parties are amenable to process and come within the jurisdiction of the forum. That's not applicable in the other forums that the appellees seek to have the court move this case to.
Well, I don't understand. Why not? The one defendant's a French citizen, so there, in the contract, you have a forum selection provision in the contract, and all the other defendants says, we'll go to France. So why is France not available and amenable to jurisdiction over all the defendants?
Well, Your Honor, there has been no consideration as to whether, in fact, France has a remedy for all the parties. There has not been any consideration of that, which would have been a requirement before the court could dismiss our case on forum nonconvenience, Your Honor. And that, if you will, would have been the appellee's burden to provide such evidence. Your Honor, I see that I have 5 minutes, and I was hoping that I can save my last 5 minutes for rebuttal.
You got 4:38 or whatever it says. So
all right, Your Honor.
All right, Mr. Foster, you ready?
Good morning, Your Honors, and may it please the court. Zach Foster on behalf of all appellees. At its core, this matter is a contract dispute between a French doctor and a French company regarding royalties paid in France owed under a French contract.
Well, I think it goes beyond that. Once Levine starts, and I have to say that having gone through and tried to figure out who all these parties are, there are a lot of moving parts here, and it might have started out as two French citizens making an agreement in France. With all due respect, counsel, you're well beyond that now.
Well, I think, Your Honor, 2 points. At its core, what Dr. Hovorka is actually arguing is that his royalty was diluted. And the basis for his dilution are two contracts. Number one, the assignment agreement between Dr. Hovorka, a French citizen, and LDR Medical, a French company. Under that assignment agreement, his royalty is triggered either in two instances. One, if LDR Medical sells a device directly to a hospital or surgeon, he gets his 1% royalty. Second, as Mr. Walters said earlier, if LDR Medical sells a device to a third-party distributor, as most medical devices are in fact distributed, then that's what triggers his royalty payment. Here, the distributor is LDR Spine. If we look at the exclusive distribution agreement, the price for the medical device, Mobi-C, is set based off the average in sale of the device to surgeons in the United States, 35% of that price. Whether or not Dr. Hovorka has a claim to say that price isn't high enough, that's essentially what his claim is, that the sale between Mobi-C and LDR Medical was not high enough. Because that sale was not high enough, the price was not high enough, his royalty was diluted. That sale between LDR Medical, a French company, goes to LDR Spine, a Delaware corporation with a principal place of business in Austin, Texas. There is no connectivity to Florida when that sale occurs. It doesn't matter to Dr. Hovorka where the sales occur. It could be Florida, it could be Montana, it could be Indiana. At the end of the day, what Dr. Hovorka wants is to be paid more for that sale. And because that is the damages in this case, the tort, if you will, did not occur in Florida. There is no connection to the state of Florida. The fact that
but the connection is the sale of the devices in the state of Florida.
Well, that's not a tort, Your Honor. And if we're going to look through there are four theories of jurisdiction.
Well, it hasn't been determined whether it's a tort yet.
Well, Your Honor, I think that's the issue here. The tort itself isn't a sale. The sale of the product doesn't harm Dr. Hovorka. The sale of the
sale of the product, at this point, is just in terms of whether there are sufficient minimum contacts with the state of Florida.
Correct, Your Honor. And only one company sold Moby-C in the state of Florida, and that would be LDR Spine. And we're not contesting that LDR Spine. We didn't appeal the ruling from the trial court that LDR Spine had specific jurisdiction based off the sale of its product. However, no other defendant, no other appellee, based on the uncontroverted record evidence, sold or directed the sale of Moby-C in the state of Florida.
All right. Do you represent to the court right now that every defendant in this case consents to jurisdiction either in Indiana or in France? I'm talking everyone.
Yes, and not just either in Indiana or France, in both Indiana and France. And that's a distinct issue from what Mr. Walters is arguing. We are saying that Dr. Hovorka can sue all of the defendants either in Indiana or either in France. And that goes to the forum nonconvenience argument here, which is a threshold issue in this case. If you
represent and you're representing all these entities here today, and you're saying to this court that each one of them will consent to jurisdiction in Indiana or in France.
Yes, Your Honor.
Okay.
And so on this appeal, turning to forum nonconvenience, which again is a threshold issue, disposes of this entire case. We don't even need to get into specific jurisdiction, alter ego, or any of the other extraneous jurisdictional theories before the court. Forum nonconvenience is reviewed in an abuse of discretion standard. Even where the trial court doesn't hold an evidentiary hearing, it's still given substantial deference on its holding. And I would also note that Florida case law states that a forum plaintiff is given no weight in their choice of forum. And the courts have also noted that they're suspect of a plaintiff avoiding litigation in their home forum. Here we have Dr. Hovorka, a French doctor, attempting to litigate claims in Florida rather than France, where he is A, domiciled, and B, the contract that is the crux of all the claims, whether or not there are additional conspiracy claims, calls for disputes to be litigated in Troyes, France. The only issues that Dr. Hovorka has challenged on this appeal with respect to the court's forum nonconvenience analysis is the first prong of the Kinney test, which is that the forum is both available and adequate. And as to availability, as we've discussed, all of the appellees have consented to jurisdiction in both Indiana and France. And as Judge Lambert said earlier, there's no question, at least with respect to Indiana, you can consent to personal jurisdiction. That's
Is there any possibility that you would need a judge to go over there and handle discovery matters? I think Judge Lambert would agree to do that.
Correct. I mean, that's one of the
reasons. My
wife
wife would think that was a good idea because she doesn't know.
I heard Troyes, France is a lovely place to oversee litigation disputes, but we're also consenting to litigation in Indiana. But I will say that the trial court cited a Sixth Circuit decision, which is Solari Goodyear tires, in which the Sixth Circuit, surveying multiple other cases, found that France is an adequate forum and that France will not reject a stipulation of jurisdiction by a U.S. company. But again, we have Indiana, where it's clear that if we submit to jurisdiction in Indiana, Indiana is not going to kick out our submission of personal jurisdiction.
Well, the adequacy. Go ahead.
Go ahead.
The adequacy argument from Mr. Walters seems to be that he has certain causes of actions or claims of damages that may not be recognized in France, or maybe more specifically here, you've not shown that they're recognized in France, and that's your burden to do that. Therefore, the trial court abused its discretion in finding that because there's no competent substantial evidence to support that. Is that your understanding of his argument?
That's my understanding of his argument, Judge.
How do you respond to that?
So as an initial matter, he's misstating what adequacy actually means. And if you read the case law, it's not that he gets to have all of his causes of action in any jurisdiction. It's actually the opposite. It's that a jurisdiction is only inadequate if the remedy available there amounts to no remedy at all. He doesn't obviously get to argue FDUCPA claims in Indiana, and that doesn't destroy adequacy. It has to essentially deprive him of all his remedies, or he would be treated unfairly. I think Dr. Hovorka cannot credibly argue that litigating his case in Indiana will amount to no remedy at all. And I don't think appellees need to offer evidence for the self-evident proposition that Indiana has common law claims for breach of contract and other related, tortious interference claims.
What about France?
Well, I mean, again, France, if we look at the Solari decision cited by the trial court, that court found that France is adequate for breach of contract claims and similar claims. And it cites 4 other published decisions that have found that decision. But again, even if we set France aside, we've got Indiana, and we only need one of the 2 forms. And Indiana, again, we've stipulated to jurisdiction in Indiana. And clearly Indiana can handle Dr. Hovorka's claims for breach of contract and tortious.
Well, let me ask this. If it was Indiana and it was in the winter, could we send Judge Harris up there to supervise this litigation?
Of course, Your Honor. I mean, Indiana in the winter, is it's not quite in East France, but I think I don't think that, necessarily is a factor against my client here. Okay. And on Dr. Hovorka's end, he doesn't rebut any of this. He doesn't say that Indiana, he offers no case law that says that Indiana can't handle his claims. He offers no case law that says France can't handle his claims. Essentially, he's just saying that we didn't satisfy our burden, and clearly we did. The trial courts cited a Sixth Circuit decision that we provided that multiple other courts.
And why is Indiana a more convenient forum than Florida?
Most of the Zimmer entities are headquartered in Indiana, and that goes to the general jurisdiction analysis. I mean, Zimmer Inc. is headquartered there. Zimmer Biomed is headquartered there. That's really the nerve center of the whole Zimmer Biomed corporate family is in Warsaw, Indiana. So I think, Your Honor, it's unequivocally clear that the trial court did not abuse its discretion in dismissing the case for form nonconvenience, and therefore the panel should affirm the dismissal on that basis. But turning to the jurisdictional arguments, Dr. Hovorka presents essentially 4 jurisdictional arguments: general jurisdiction, specific jurisdiction, jurisdiction through an alter ego claim, and jurisdiction through conspiracy. And starting with general jurisdiction, Dr. Hovorka's claims that Florida can assert general jurisdiction, and he names 4 of the entities that he thinks have general jurisdiction, and that's LDR Spine, LDR Medical, Zimmer Holdings, and Zimmer Inc. His basis for that argument is flawed because he's relying on an outdated standard for what constitutes general jurisdiction. Specifically, Dr. Hovorka repeatedly claims that he satisfied his burden for general jurisdiction because certain appellees have continuous and systematic contacts with the state of Florida. However, the United States Supreme Court in its decision of Daimler versus Baumann expressly rejected that substantial and continuous contacts standing alone are sufficient for the due process prong of the jurisdictional analysis to grant general jurisdiction. Instead, the Supreme Court reiterated that there are 2 paradigm forms: a company's state of incorporation and principal place of business. Now, it also recognized that there is an exceptional third venue, and that is where a forum defendant's operations in a state are so substantial and of such a nature to render the corporation at home in that state. But why that's different than continuous contacts is it requires a qualitative versus a quantitative analysis. Essentially, you have to look at where a company operates across all the forms in which it operates and decide, is its activities in a single state, does that make that state essentially its surrogate headquarters? And if you look at the Perkins v. Bingett case back from the 1940s, that's really the only case that the Supreme Court cites to as an example of that exceptional third forum. And in that case, you had a Philippine mining company that was displaced from the Philippines in World War II. And because of the Japanese occupation of the Philippines, they had to take their corporate headquarters, their corporate staff, all of the records, and move them to Ohio. They weren't incorporated in Ohio, and Ohio wasn't their official principal place of business, but because they were displaced from the Philippines, and Ohio became essentially their nerve center while the Japanese occupied the Philippines, the court recognized that Ohio could count as a general jurisdiction state. Here, Dr. Hovorka can't demonstrate, he can't demonstrate that Florida is home to any of the appellees. The appellees presented uncontroverted evidence that LDR Medical, Zimmer Inc., and Zimmer Holdings do not regularly conduct business in the state of Florida.
Well, What contact does Zimmer Biomet France Holdings have with Indiana?
None, but we've consented to jurisdiction. None, at least from a record standpoint. But we've been sued and we've consented to jurisdiction in Indiana. And because of that, it's an adequate alternative forum. And so turning back to LDR Medical, which does have obviously contacts with the state of Florida, LDR Medical, sorry, LDR Spine, which does sell Mobi-C in Florida and conduct substantial business here. We've presented evidence, uncontroverted evidence, that the sales in Florida are actually a small percentage of LDR Spine's overall sales in the United States. And because of that, the sales in Florida are not so substantial as to render Florida LDR Spine or LDR Spine's headquarters when it's already headquartered in Texas and incorporated in Delaware. Now, as to,
do you think the test is the percentage of business that a company does in Florida? I mean, if they're doing, let's say it's $1 billion company and they have $100 million worth of sales in the state of Florida, you're suggesting that we would look at the percentage between their general total revenue and the amount of revenue obtained through sales in Florida. And that, what authority do you have for that proposition?
the Daimler case, Your Honor, 2014.
I'm very familiar with the Daimler case. I'm not sure that, go ahead.
I mean, if you read the dissents to it, they explicitly reject the proposition that substantial sales alone give you general jurisdiction. Otherwise, a large company, to your example, would be subject to general jurisdiction in every state, and that's simply what the Supreme Court rejected. Now, you could have specific jurisdiction in that state, of course, if those $100 million in sales, there was a claim based on those sales. We're not obviously contesting that specific jurisdiction wouldn't apply, but for general jurisdiction where you can be sued for things that happen in France and Florida, you've got to show that it's essentially the company's surrogate headquarters. Otherwise, the two paradigm forms are a company's principal place of business and state of incorporation. Again, the Supreme Court rejected large companies would be unfairly penalized and they'd be subject to jurisdiction nationwide. So there are a number of kind of factual misrepresentations that Dr. Hovorka makes in his pleadings, and I'm happy to address any of those. But I think one that bears discussion is Dr. Hovorka's conflating the term Zimmer Biomet with the company Zimmer Biomet Holdings. The two are not synonymous. Zimmer Biomet is a trade name used by multiple subsidiaries to describe the subsidiaries and also their product, where Zimmer Biomet Holdings is a distinct company. There's multiple times throughout the record in affidavit and deposition testimony where deponents and explain to Dr. Hovorka that no, Zimmer Biomet does not mean Zimmer Biomet Holding. Yet Dr. Hovorka repeatedly in his briefing cites out of context deposition testimony or documents that aren't verified that say Zimmer Biomet, and Zimmer Biomet does X in Florida, but it's not talking about Zimmer Biomet, it's talking about some subsidiary that's using Zimmer Biomet as a trade name. And I think more importantly for all of these factual disputes that Dr. Hovorka raises, the top line issue is that he's not entitled to an evidentiary hearing, because even if he's right on everything, even if he's right on all of these, if you grant him every factual dispute, it still doesn't get him to the threshold of general jurisdiction. It still doesn't arm the court with the evidence that it needs to make a qualitative analysis to find that Florida is a surrogate headquarters for any one of these appellees. And because of that, general jurisdiction fails. And turning to specific jurisdiction, the only entity on appeal that Dr. Hovorka is arguing is subject to general jurisdiction is Zimmer Holdings. And again, to show specific jurisdiction, you've got to show not only contacts with the forum, but that the plaintiff's claims arise out of those contacts with the forum. And Dr. Hovorka's theory in his brief is that the trial court could have exercised specific jurisdiction based on what he claims are Zimmer Holdings' direct involvement in the sale of Mobi-C to medical practitioners in Florida. But Zimmer Holdings, in its affidavit evidence, presented unequivocal statements that it does not manufacture, distribute, train, market, sell any medical devices or surgical instrumentation, including Mobi-C, in the state of Florida. And it did not otherwise direct the sale, distribution, manufacturing of Mobi-C. Per Venetian Salami, the burden shifted back to Dr. Hovorka to present evidence that contradicted that proof. He can't rely on his pleadings anymore. And just like his general jurisdiction arguments, Dr. Hovorka relies on in-state context based on factual distortions. First, he points to the fact, what he says is that Zimmer Biomed Holdings owns the LDR entities. It's simply not true. The uncontroverted evidence, as Your Honor pointed out, you have to map out the corporate chart here, but Zimmer Biomed Holdings is an indirect parent of LDR Holdings, is an indirect parent of LDR Spine. But even if it was a direct parent, Florida courts have repeatedly held that simply having a subsidiary in state and doing activities in state doesn't subject the corporate parent to specific jurisdiction. And then he points to an article. He claims that Heather Kidwell, one of the corporate secretaries for a Zimmer company, testified that MoVC was expected to be a growth driver for Zimmer Holdings in 2017. To the contrary, the referenced article that Dr. Hovorka showed Ms. Kidwell uses the term, again, Zimmer Biomed. Zimmer Biomed, again, is a trade name and has nothing to do necessarily with Zimmer Biomed Holding. And further, from an evidentiary standing, Ms. Kidwell didn't recognize the article, couldn't authenticate it, nor did she agree that Zimmer Holdings could or would realize growth from OVC sales. In fact, Dr. Hovorka's attorney asked her at the deposition, quote, did ZBH and or its subsidiaries realize the growth that the article described in 2017? To which she responded, I don't know. So that interaction just doesn't support the assertion that specific jurisdiction would apply. And third, there's Dr. Hovorka points to.
But why then shouldn't they get a evidentiary hearing to flush that out?
Because he had the opportunity to flush that out in a deposition. I mean, what would the evidentiary hearing do at this point? And in the last 20 seconds, I'll explain. We agreed to a process where we would submit all of the evidence in support of our arguments. And he submitted the deposition testimony, and the court found that could be harmonized. And because it can be harmonized, I mean, I don't know what a hearing would do at this point. We'd submit the deposition testimony again. The court would come to the same conclusion that what he's saying in that deposition testimony isn't true. And I'm obviously over time, so I yield the remainder of my non-existent time.
Okay.
Very, very sporting of you. Okay, Mr. Walters, you have 4 minutes and 34 seconds for rebuttal, sir. Go ahead whenever you're ready.
You got to unmute. It'll help us hear you.
Can hear you.
There you go.
Sorry about that, Your Honor.
No problem.
Your Honor, I'll address a couple things that Appley's counsel has stated. With regards to the adequacy of France, this court in Sawana Bank versus Cato 15 CA decision that I've previously mentioned, it states an alternative form is adequate when the parties will not be deprived of all remedies or treated unfairly. Again, counsel for the Appleys represents, well, some of the remedies might, but that's not the standard. That's not the criteria. And as a result of it, France is not an adequate form for a variety of reasons. More importantly, there is no presentation of any type of evidence or anything to support that France would even entertain such a case.
Mr. Walters, I thought that we had discussed on your initial presentation as to whether all of the parties had consented to jurisdiction in Indiana and in France, and you had indicated that all had not. And that is not some, Mr. Foster apparently contests that statement. And which is it?
Your Honor, it was my understanding that all had not. And Mr. Foster is representing that all in fact has. Again, if nothing else, those are some of the conflicts that needs to be.
Well, I think at this point, he better not go into a lower court and take a different position. This is he's making that representation to us as a Florida court, and I would think he would be hard pressed to back off of that, either in France or in Indiana.
Well, Your Honor, the mere fact that the Appleys would stipulate to having France have jurisdiction over this matter without representing or having anything to support that France would in fact take this case is a problem, because what the court would then be doing is dismissing it with an assumption that would actually occur.
But remember that we start with the venue provision that your client selected.
But Your Honor, the venue provision only relates to LDR Medical. That's the only contract. There's several other defendants. What is interesting is that Appellee's counsel represents that LDR Spine is the only one that was doing things in Florida. In fact, LDR Spine was under the authority through the exclusive distribution agreement as to whether it could in fact sell the Mobi-C in Florida. LDR Medical literally controlled LDR Spine as an agent to address these things. So for the appellees to represent that it's only LDR Spine has any relationship to this is not correct. What I find also interesting, since LDR Holdings, or I should say, since Zimmer Biomet Holdings was the one when they purchased LDR Holdings, which is undisputed based on the deposition testimony of Ms. Kidwell, they have created more shells to hide the revenue / royalties owed to my client, because it's undisputed that it was Zimmer Biomet Holdings that bought the rights to my client's invention and has continually generated revenue from that right and has not paid my client. If ever there's an unjust enrichment, if ever there's a theft, it's for Zimmer Biomet.
Well, but we're not really addressing the merits. I mean, maybe your client's correct and maybe your client isn't correct. All we're really discussing here is just the jurisdictional aspects of the case.
And Your Honor, in relationship to the appellee's counsel's representation about specific jurisdiction, we properly pled that these are co-conspirators with Mr. Levine in his scheme to steal the royalties of my client. And as a result, there is not we don't get to the second prong of Venetian salami, Your Honor. In your case, in the case of Matt Tinger versus Inertial Airline, which is represented in our brief, you don't get to it when you have properly pled that there is a conspiracy and an alter ego in relationship to the minimum contacts. We properly pled that Mr. Levine, LDR Spine, and surely we're not questioning whether LDR Spine, if you will, is Florida, then we've satisfied the specific jurisdiction requirement. In relationship to the general jurisdiction, there has been no testimony, whether through affidavit or deposition, that contests Zimmer Inc.'s level of activities that it could be that the court would have general jurisdiction over it. And the fact that it has 96 lawsuits in the state of Florida supports and further supports that it has general jurisdiction. The fact that Zimmer Biomet Holdings wrote to the Florida Supreme Court talking about how much business it does and that the court should be persuaded to continue using the Dauber expert witness standard versus Fry goes further to support that they surely had a belief that they would be held into courts. And more importantly, they wanted to protect that belief and ensure that the expert testimony standard we use is Dauber.
Okay, Mr. Walters, you've gone past your time. You want to just wrap it up? We'll be good.
All right, Your Honor. So in wrapping it up, we're requesting that this court find that there's specific jurisdiction of all the appellees pursuant to the conspiracy and alter ego, reverse the dismissal for form non-convenience, and at minimum, send this back for a limited evidentiary hearing to address the conflicts between the affidavit and the evidence.
Okay. All right. Thank you, counsel, for your respective arguments. We appreciate them. We will now stand adjourned and conference the cases today.
Thank you for your time, Your Honor.